Good morning, everybody. Thank you all for joining us. Let's see, we are almost all in from the waiting room. So I'm going to go ahead and get started with our Zoom housekeeping tips as we usually start our meeting. And let's see, why are there two people hung up in the waiting room? Hopefully they'll make their way in here pretty soon. Okay. Sorry about that. I'm going to start, like I said, with our Zoom housekeeping stuff and remind you to please go ahead and stay muted for the duration of the Q&A unless you want to unmute yourself to ask a question. You're welcome to do that, but we just ask you to stay muted otherwise so that it cuts down on background noise. And if you're newer to Zoom and not sure where your mute button is, it's in your Zoom toolbar. That's also where you will find your start and stop video button. It's also where you'll find the chat button, which the chat is a great way to ask questions or ask us to clarify something that we've said during our session today. That might actually be flashing for you because I put a message into the chat, and the message just reminds everybody that if we don't get to your question by the end of our session today, or if you think of a new question for next week, please email those to info@condolaw.net by 4 p.m. on Monday afternoon so that we have time on Tuesday to research our answers and be prepared for the following week's Q&A. In the chat, I also posted a link to our YouTube channel where you can view all of the videos that we have done for this Q&A since we started back in April of 2020. So I can't believe we've been doing it that long, but we have. So you can also search in our particular channel as opposed to doing a general YouTube search at the top of the page. There's a little search whatever area further down on the page when you're in our channel by topic. And so sometimes, as long as it's not a super common topic, a word that would be in our prep document every week, you might be able to find good results by doing a search for topics as well. As we remind you guys every week, we are not here to give legal advice. We did have a couple of questions this week that were many paragraphs long, and one of the things that we're going to say when we read those questions and try to answer them from a really general perspective is that we can't give advice. You can't rely on what we say in this Q&A as advice. If you find yourself sending us portions of your governing documents or really specific sets of facts from your community, then you're probably asking for legal advice, and we can't answer those questions in this context. So that said, we do try to at least cover the topics generally when we can. And if somebody sends you a link to a Q&A and says you have to do this or you can't do that because of something that Valerie said or Katie said or Ken said, you can just ignore them because this is not legal advice. Please also keep in mind that, as I mentioned, the chat function is just for asking questions or requests for clarification, not for commentary like you sometimes see on the CAI message boards. We have been reminding everybody or saying this for a while now, but I'll just put in a plug again to say that the Corporate Transparency Act is still being challenged by National CAI. There's also still a appellate decision out there in a different circuit suggesting that it might be unconstitutional. That's not binding in our circuit. So all of that is just to say that there is still some uncertainty as to whether the CTA requirements are going to actually take effect in January of 2025 as we currently think that they will. So we're telling our clients at this point that it's fine if they feel comfortable waiting, holding off before they start taking steps to comply, because a lot might change in the next 6 months or 7 months before that act takes effect and the reporting requirements are part of the deal. And so, of course, if there are any changes on that, we'll definitely keep you guys posted. The other thing that we want to remind you all of is that Senate Bill I can't even remember the bill now, 5796, I think, the WUCIOA for All bill. I think everybody got really focused on the WUCIOA for All part of that bill and kind of forgot for a while that there are a number of revisions to the existing WUCIOA bill or statute that are going to take effect this year. They're going to take effect in just a little bit less than a month on June 6th. So we will be talking about some of those changes today. We'll be talking about some of those changes, of course, in the coming weeks. But this is something really that only WUCIOA communities, only communities that are currently governed by WUCIOA, need to be aware of for this year. So none of the changes that go into effect for WUCIOA this year are universally applicable. So none of the provisions that go into effect next month are going to affect anybody other than communities that are governed by WUCIOA. That being said, some of the changes are to the records section, to the voting/proxies section. And so we've had a couple, not quite 2 years, where all 4 of the statutes matched exactly when it came to voting and things like that. And we no longer have that matching, which is annoying. However, the light at the end of that tunnel is that in a few years, when WUCIOA for all does go into effect for everybody, January 1st, 2028, then we will only have 1 statute to deal with. And it might change every year, but we still will only have 1 statute to keep track of. We do probably have time for extra questions today. So if you're on the fence about whether to put a question into the chat and are wondering, this is not one of those weeks where we have 32 questions that were submitted in advance, and we will likely have time to get to things from the chat if you want to pop a question into the chat. Katie, did you want to say anything else, or should I jump into the questions?
Go ahead and jump in.
Okay, so here's our first one. We have a 6-unit cap on rentals, which is less than 10% of our 67 lots. Our CC&Rs were amended in 2003 to specify a maximum of six rentals with a 3-year limit on any one owner's exercise of the leasing privilege. If at the end of the 3 years there is a waiting list, the owner whose term is up goes to the end of the waiting list. Is there anything in WUCIOA, existing or contemplated, that would prevent our association from limiting rentals to 3 years? Last week, you mentioned you would provide the RCW section related to rental cap rules under WUCIOA, and I'm wondering where those will be posted. And is there anything in those rules to prevent an HOA from limiting the number of years an owner can lease their unit? So the answer to this question is no. There is nothing currently or upcoming in WUCIOA that would prevent an association from limiting rentals to 3 years, assuming that restriction currently or already exists in your governing documents. Because this amendment, it sounds like the person who submitted the question said the amendment was recorded in 2003. That's a longstanding restriction within your community. It's not going to be invalidated by anything that exists in the current statute or the changes that are coming down the pike next month. But again, the restriction must already be contained in your current documents. WUCIOA doesn't contain any specific restriction on rentals. Like, it doesn't say you can only restrict rentals up to a certain percentage, or you can't have an occupancy requirement or occupancy, so there's nothing super specific in WUCIOA like that. However, the current version of WUCIOA, which is 6490-285 at subsection 6, it currently requires that all current unit owners be exempt from any rental restriction that an association adopts, which means that if you are a community governed by WUCIOA and you don't already have a rental restriction and you adopt one, it doesn't apply to your current owners. However, this is one of the things that's going to change next month. This part where it requires you to sort of protect current owners from the rental restriction you adopt is going away, and it will be removed from the statute starting on June 6th. So WUCIOA communities can adopt rental restrictions that apply to current owners and which may not require every owner to agree, but not until June 6th going forward. We don't know why the change was made. I do suspect that it probably had something to do with wanting to allow communities to adopt rental caps and perhaps limit short-term rentals. So again, if you're a community that's governed by WUCIOA, starting in June of this year, June 6th, you don't need 90% or 100% of your owners to agree to a rental amendment, and it can apply to current owners. And so that's a significant change for WUCIOA communities. If your community has been around since 2003, so you're not, I'm assuming you're not a WUCIOA community. And for any community that's not a WUCIOA community, this stuff is essentially irrelevant until January 1st, 2028, when you will then be subject to WUCIOA. Katie, did you want to add anything to that?
The only thing I'd add is that if you want these restrictions, and it would be a lot harder because you're maybe a new act condo that would maybe require 90%, this might be a reason to adopt WUCIOA early, so that you can benefit from not requiring a supermajority and allowing all, or exempting all current owners. Just something to consider.
Yeah.
Next question. With the approaching summer, can you please review the new heat pump legislation? 5973 is this bill number, if anyone wants to look at it, that goes into effect in June. Will this supersede any bans or restrictions already established in the governing documents? What could be considered a reasonable justification for denying an application? In the past, you mentioned having the owner sign a hold harmless agreement to agree to the cost responsibility of installation, maintenance, damage, etc., and recording it against the property. Is this still suggested? So we have reviewed the upcoming heat pump legislation. It does apply. There's a section that's going to apply to every community in every statute. It looks really similar to the existing EV charger legislation that passed 2 years ago, maybe a year ago. And
I
so
think it was 2 or 3 years ago.
yeah. But it's very similar language. It kind of looks like they just substituted heat pump for EV charger, but a lot of the same rules apply. The bill means that the association must allow an owner to install a heat pump in their unit if the owner pays for it, follows reasonable restrictions adopted by the board, which could include requiring a hold harmless. The bill also includes rules about requiring insurance and other considerations, and it does make owners responsible for maintenance and removal of the heat pump. The statute will supersede any conflicting provision in the governing documents, especially ones that restrict or prohibit heat pumps entirely. There are maybe some reasonable reasons to deny an application. Obviously, if the owner is unwilling to pay for the installation, that's a pretty good reason. We would need to know more about the specific application to say if a request should be denied. It is unlikely that denying a request because it looks bad or for aesthetic reasons would be reasonable. You could talk about screening it and that gets into more specifics. Other justifications may be to refuse for noise or other nuisances it causes. Some heat pumps are really loud, and if they're super close to another unit, that may be a reason. But again, we would need to know if someone applies, and if you want to deny it, we would need to know why, if there's another workaround. It's going to be a lot harder to deny it just because you don't like it or without a good reason. Whether or not a hold harmless document is recommended depends on the community. For HOA communities under 6438, probably not going to be required because the heat pump will be entirely within the lot. For condos, it might be necessary because the heat pump may be attached to or in the common elements. So that's something to consider. You should probably contact your association attorney if you're considering it. We did once have an argument that the installation of a heat pump for a unit in the common elements is converting a common element into a limited common element and would require the approval of all the owners and a bunch of other stuff. We don't think that that's a valid reason or excuse to, I guess, one, deny a heat pump or that would survive really a court challenge. We also don't think it requires approval from all the owners. So if that was kind of a path you were thinking of going down, I don't think we would support it. Valerie, do you have anything to add on that?
Yeah, I mean, I guess the one thing I'll comment is to just shed some light on some of the reasons why the legislature decided to pass this bill. And this might just be super obvious to some of us. I mean, 2 summers ago, it got to 117 degrees in my backyard, and I live in Bothell. I do not live in Eastern Washington. And granted, that was only one day, but our weather has changed really significantly, and the majority of existing housing in Washington state does not have air conditioning, and it creates a hardship for people. I mean, it creates a hardship for people who are healthy and don't have any extra challenges. And then on top of that, if you have anybody that's a fragile, like has fragile health problems, whatever. So this was a really big part of the legislature's rationale behind making it easier for people in community associations to install heat pumps. But do keep in mind that this is not something where they can demand that the association do it. They can just put in whatever they want. They do still have to ask for permission. You can have reasonable restrictions, such as asking them to choose. There's lots of heat pumps now that are very quiet. And so you can require that there be some sort of limit on the amount of noise output if you are not in a single family home community. I think it'd be harder to make that argument in a single family home community, but you can't prevent them just because you don't like them. You can't prevent them just because you don't think they look good. And I also want to clarify, this is limited to heat pumps. So this bill does not mean that people can go installing window mounted air conditioning units in every window of their condo unit. So do keep that in mind, but also check with your lawyer before you deny an owner's application for something like this, just to be sure, because that also shifts some of the risk of that denial from your association to your law firm if you're relying on their legal opinion to make a decision that you're to deny an application. So,
and I did put the link for the raw text in the chat if people want to read it themselves.
Thanks, Katie.
It also defines heat pump under the statute. So if you're curious as to what they're defining it as, that would be good.
Thanks, Katie. All right, I'm going to jump into our next question. If the original governing documents don't specifically allow an association to create new restrictions, what happens if a simple majority later amends the covenants to give the association the power to create new restrictions? Would homeowners who took title under the covenants that did not allow new restrictions be bound by the new restrictions, or would they be grandfathered in? I'm going to, as an aside, just take a moment to address the use of the term grandfathered in. I think not everybody knows that that is a problematic term, that it stems back to the Jim Crow era and has its roots in ways that Black people were prevented from voting even after they were given the constitutional right to do that. So just because it's always good for us to learn and use new terminology when we realize that old terminology is problematic, I just wanted to take that little sidebar and give you guys that information. I'm going to continue reading the question now. Chiwawa versus Wilkinson and Schaefer versus Board of Trustees are two cases that say in part that new restrictions are allowed if owners have notice of the reservation of power that allows the association to create new restrictions. In the Schaefer case, the original 1960 Articles of Incorporation allowed the association to create new restrictions, and all of the homeowners purchased their homes after those articles were recorded. The court allowed a majority vote instead of requiring approval by 100% of owners to add new restrictions that would be enforceable against all property owners. But I haven't found a case where the reservation of power was added after homeowners took title. I think the reason you haven't found a case like that is because there isn't one. And I think the answer to this question would largely depend on the type of restriction that you're trying to adopt. I also think that if a simple majority adopts a new restriction, it may not be enforceable against the current owners because those are the purchasers that did not have notice that a certain type of restriction could be adopted, right? The future owners would be on notice after that restriction is adopted. So maybe this is the kind of amendment that would take effect over time as people sell their properties and new people buy into the community. We don't think a two-step process would succeed in, for example, allowing a rental restriction in a community that had documents similar to the community in the Chiwawa case. In other words, we don't think this approach would allow you to achieve the opposite result of the outcome in the Chiwawa case. And Schaefer doesn't address whether you can add first the right to change things and then change things later based on that amendment allowing you to change things, right? And I also think it's worth pointing out that the cases that are referenced here, number one, Chiwawa is the more recent one. So I think it is certainly binding. There's no question of that in Washington, and is the more binding of the two and the more persuasive of the two because it's more recent. And I did not read those cases to suggest that simple language in your declaration saying, someday we might add other restrictions to these documents and those will be enforceable, that having some super general blanket right to add restrictions would have cured or given us the opposite outcome as we got in Chiwawa. I think what the court in Chiwawa looked at was that there was if there had been some right to restrict or administer rental rules, for example, then a later adoption of a rental restriction might have been enforceable. But because the CC&Rs were completely silent on the issue of restricting rentals. Adding that new restriction later was found to be unenforceable. So I'm not sure that general catch-all language that says we might add further restrictions in the future would actually change the outcome in Chiwawa. I think what the court was looking for in the Chiwawa CCNRs that it did not find was anything referencing a restriction on an owner's right to rent their home. It was completely unrestricted in the original CCNRs. So one thing that I will point out though is we get a lot of questions from people that are kind of upset by the outcome in Chihuahua. We get a lot of emails from HOA clients that wish that they could adopt rental restrictions, single family HOAs. And one thing that you can do to try to lobby for this kind of change is to contact your legislator and ask them to define short-term rentals as a commercial use in our state laws. Because there are a lot of governing documents that already restrict commercial or business use within the residential lots or units within their communities. And if the legislature simply adopted a definition of short-term rentals to say short-term rentals in Washington state are considered a commercial use of property, then you wouldn't even need to adopt a rental restriction necessarily to prevent short-term rentals within a community, as long as you already had a provision prohibiting commercial use within the residential lots in your community. So don't discount. I mean, I think a lot of times we think, well, how much power can one person have? My legislator is not going to listen to me. I mean, we just had a huge shift in our governing statutes that's going to take effect in January 1st, 2028, because the prime sponsor of this bill, the WUCIOA for All bill, was convinced by certain people that it was important enough to try to make this change. And here we are now looking at this change coming down the pike. So if enough people contact enough representatives to ask for clarity on this issue, the legislature can do this. And if the legislature does this, it makes the outcome in Chihuahua maybe different, just by virtue of creating a definition of what a short-term rental is. So I don't want to get too much further into the weeds on that question. Katie, did you have anything else you wanted to add?
Nope. So I'll jump into the next one. If a board has already voted to approve some covenant amendments to propose to the membership and are working on the ballot and summary, and then learn that a proposed amendment is not compliant with the law, what should the board do? Without knowing what the amendment's for, the board should consider revising the amendment to be compliant with the statutes before sending it to the owners for the vote. And we have a lot of things out with boards right now for amendments, and with all the changes in WUCIOA that, our office is having to bring back and fix before they're sent to owners. So this is not an uncommon thing. It doesn't mean you did something bad. It's just the legislature always updates things. But we think it would be best to make sure it's compliant before you send it out. We would need to know if the amendment is prohibited or the documents could allow for something. So for example, proxies. The statute sets out a default, but it allows the governing documents to have a different procedure. So it may not be that your amendment is contrary or not compliant with the law. You can be clarifying it further. If the amendment is passed by the owners in its current state, basically in a conflict with the law and recorded, and it's inconsistent with the statutes will prevail and make whatever the amendment says irrelevant. So basically, you could record it as is if it gets the votes. It just won't have the desired effect probably that you wanted it to. We recommend, if you're in the situation, that you work with your association attorney to draft an amendment or to revise the current amendment to be consistent with the state law. Valerie, anything to add on that?
No, I might have, I think what I wanted to shout out right when you were done reading the question and before you started your answer was talk to your lawyer. You talk to your association attorney. And like Katie mentioned, sometimes this happens because your law firm is drafting or has drafted an amendment, and it's maybe gone back and forth between the board and the lawyer a couple of different times, and then the legislature ups and changes things. So that makes the amendment out of date or potentially inconsistent with the statutes. That's one thing. That is something that your attorney should be able to fix, or that you as a board can determine, the majority of the amendment is fine as it is, and we just won't try to enforce this small section that's inconsistent with the statute. We're going to move forward with it as is. That's one scenario. The larger concern that I have is that we do occasionally run into boards that try to draft amendments themselves. And it sounds really self-serving to say this, but every single time we have had a client come to us with a self-drafted amendment and asked us to review and revise it so that it is consistent with the law and with the procedures that are necessary for a valid amendment, it costs the association way more than it would have cost them if they had just paid us the flat fee to draft the amendment to begin with. So if part of this question is coming because you guys are, your community is self-drafting amendments, I would absolutely caution you that those should at a minimum be reviewed and revised by your attorney before you record them. And I would generally recommend and say that it's cheaper to, in particular, if you're using a law firm that has clearly defined costs, flat fees, whatever, your costs are probably going to be lower to have an attorney just draft it to begin with, especially because if you draft a bad amendment and record it and try to enforce it, there may be costs associated with trying to defend challenges to that amendment in the future. And part of what we try to do is try to help you avoid that by drafting these documents as cleanly as possible.
Val, really quick, I think there's also a different question is if you're trying to adopt an amendment now and what your amendment is not compliant with UCIWA, but you're not a UCIWA community and it won't be compliant in 2028, that is a different question that you should talk to your association attorney about to see if it's worth revising it to be compliant with UCIWA now, even though you're not a UCIWA community, or just doing it and waiting till 2028 and having it not be effective. So that's a separate question than it not being compliant with a current statute that applies to you.
Yeah, that's a great point. Okay, I'm going to jump into our next question. Our association board hired a law firm to review proposed amendments to our governing documents. Preparation of proposed amendments, a ballot, and explanation is currently in process. A member of the community wants the full set of comments provided by the law firm to be shared with all of the association members. Is this a document that is required to be provided to all owners under current law, or would it be protected by attorney-client or attorney work product privilege? If it should be shared with the members, please provide any process the board should follow to do so. Generally, communications between the board and the association attorney are communications that are protected by the attorney-client privilege, and they are not subject to disclosure in response to an owner request for association records. The board is the group of people that holds the privilege on behalf of the association, and the board as a whole gets to make a decision whether to waive the privilege and share any such documents or not. I want to point out the way that I emphasized the board as a whole holds that privilege. No individual board member can make a decision about this, and a board member can't be on the board when something's happening and then leave the board and then later share stuff that was attorney-client privileged when they were on the board under some theory that it no longer counts because they're not a board member, right? If a document or a communication is protected by attorney-client privilege, only the board that is in power at the time the decision is made has the authority to waive privilege or not. So if your association attorney provided the board with comments on the proposed amendment and in a communication back and forth among the board members and the attorney only, my general opinion on that would be the default is that it's protected by privilege and would not have to be disclosed in response to an owner's right to review records. And in addition to that, an individual owner asking to see something is different than an individual owner demanding that something be shared with the entire community, right? So those are two different things, and I just want to make that distinction. I think there are scenarios in which a board could absolutely decide, yeah, we want to go ahead and let the ownership see the comments that were provided to the board as we were working on these amendments together with the attorney, and the board has the authority to make that decision. And in that scenario, the one thing I would beg you to do is check with your attorney before you disclose attorney-client privileged communications. Often we approach the way that we communicate with a board, understanding that that communication is protected by privilege, in a way that is very different than how we would choose to communicate if we knew that something was going to be disseminated to the entire community. And it's not about dishonesty or being disingenuous. It's really about talking the boards through the pros and cons of certain things as the board makes decisions on how they want to move forward. And sometimes those conversations are fine to disclose to the ownership, and other times it can create confusion, or the board might just decide we don't want that whole discussion to be privy to the entire ownership, or the ownership to be privy to it. And so check with your association attorney before you disclose those things, because if you waive once you waive the privilege, that's you know, the barn door is open and you can't, the horse is out. Like, that's not something you can undo, right? So you want to make sure that you're consulting with your attorney both on whether it's a reasonable thing to waive the privilege and to disclose the communication, as well as if there should be any modification to the content before it goes out to your ownership. If you decide to choose to share those comments with the ownership, you can go ahead and send them to the one person that's asking. You can email them to the entire ownership. You could post them on a community website. You could mail them out. There's no required way to disseminate those once the board makes the decision to share them with the ownership. You could even send them out with the proposed amendment when you send it out to the ownership in advance of the vote on the proposed amendments. And depending on who you're working with and what type of amendment situation you are in, there might even be a document where the attorney revisions to the original proposed amendments are tracked, like using track changes in Word. And you could even choose to send a copy of that out to your ownership so they can see the specific changes that were made. I think that really covers that topic as well as we need to, unless you have anything you want to add, Katie.
The only thing I would add is touching back on what you said about check with your association attorney first, because our comments may be not appropriate's not the right word, but it's the word I'm going to use. Appropriate for the general owners is, if you know you want to share a document ahead of time, just tell your association attorney and we'll tailor the comments in advance so it can be ready for everyone. And so if you are doing a big amendment and you want, or a restatement, and you want all the changes shown and all the comments, just talk to the person preparing the document, and that will be a lot easier than having to go back and change something. All right, next question. The HOA pool rules and regulations specify opening Memorial Day and then closing Labor Day. Does the HOA/board have to abide by those exact dates, or can the HOA choose to open or close the pool a bit earlier or later, dependent on weather? There's no specifications in the governing documents. So the short answer is yes. The board can choose to open earlier if it wants. I was going to say do whatever it wants, and that seemed a little too broad. The board has the broad authority to regulate the use of the common elements, and this includes when the pool is open. The board can just change the rules to reflect the dates that it wants open. So like right now, we're having a warmer spring than we have in the past. It may make sense to open this weekend instead of waiting till Memorial weekend. The rules really just are intended to set a minimum time to be open, and you can probably open earlier, extend the time if we have a very warm October, for example. The rule cannot create a binding obligation to open the pool if the economy or safety prevent opening. So if it's like freezing outside and it's going to be super expensive to heat the pool, it may not make sense to open it if there's snow on the ground. If you are changing, whether you're opening late, opening early, just put like a sign so people know. I mean, that's not really legal advice. That's just as someone who likes using pools, I would want to know if it's not open, and just say when it'll open. You can also just tell your owners how you normally would, but the board can largely decide when they want to open it for various reasons. You're not tied to those specific dates. Valerie, anything to add on that?
Nope, I will go ahead and jump into the next question. What changes to WUCIOA have already gone into effect universally, and which ones will not be required until January 1st, 2028? There was additional content to the question, but I'm just going to go ahead and answer it based on that short version and basically say none. There are the only parts of WUCIOA that are currently universally applicable are the parts that have been applicable to everybody for a while anyways. That's the budget ratification section, the reserve study section, and there's also a section about how you can adopt WUCIOA as your governing statute using an easier amendment process. And those are the only provisions of WUCIOA as it exists now, and also as it will exist on June 6th of this year, that are applicable to non-WUCIOA communities. If the question is about UKIOA, meaning the Uniform Common Interest Ownership Act as it has been drafted like at the national level, those do not become part of Washington state's statute until and unless our legislature actually adopts those changes. So it is actually very common that these uniform acts that are sort of originally created at the national level change. They're amended over time, just like our legislature changes our statutes over time. But those changes at the uniform template level, let's use the word template, because I think that suits the situation. Those don't get automatically imported into our statute unless our legislature adopts those changes. So our state, you may not know this, but our state did not adopt the entirety of the national uniform bill that was the original basis for our WUCIOA. In its entirety. There were some provisions that we omitted, other provisions that we changed before WUCIOA was adopted and enacted into law in 2018. So again, on January 1st of 2028, WUCIOA as it stands at that time will be applicable to all communities in Washington state. All of the other statutes will end up going away, the HOA Act, Old Condo Act, and the New Condo Act. But none of the changes that were made this year to WUCIOA are universally applicable. They only apply to WUCIOA communities or communities governed by that statute now when those changes take effect on June 6th, and none of the rest of us have to worry about those changes until January 1st of 2028. I will offer one thing that did change in WUCIOA that will go into effect on June 6th was that it was amended to allow more clearly for video conference meetings and to more clearly allow for electronic voting if people consent. And the association has reasonable measures to verify that the electronic ballot was cast by a unit owner having the right to vote, among other things. And we have a proxy related discussion that we might get to at the end of our session today that will have more detail about this. But I think the changes to the voting section of WUCIOA, which again, will only affect you if you're governed by WUCIOA until 2028, does make it so that if your community has been using sort of anonymous methods of collecting owner votes, such as like SurveyMonkey or whatever, those are no longer going to, they probably were not the best way to be collecting votes to begin with anyways. But now that there is this requirement that a board take reasonable measures to verify who is casting the vote, you're going to want to be using some sort of system that allows you to make that verification. So there are voting softwares out there. I've heard of Votegrity. I haven't looked at them directly to see if their procedures sort of rise to the level of what we think will comply with this statutory change, but that's just something people should be aware of going forward. Katie, did you want to add anything to that?
Nope, but I will jump into the next question, which is if we wish to adopt the 2028 version of UKIOA in advance, what is the most efficient way to do so? And so before we answer this question, we just want to make sure we have a clarification on terms. There is no 2028 version. There is the current version of UKIOA that will change likely every year. And you can choose to make your association subject to the current version of UKIOA early before you're forced to do so in 2028. And so if you want to do that, here's how you do it. You can adopt an amendment that adopts UKIOA as your governing statute. The provision that allows you to do that is RCW 6490-095, which is what allows pre-existing common interest communities to adopt UKIOA. It sets out a very clear process of what needs to happen. So first, the board or 20 more of the votes in the association need to
20% or more. Sorry.
Yeah, what
you
did I say?
You forgot the word percent.
Oh,
You're
Oh
good.
yeah, no, percent, not just like 20 owners, sorry. The board or 20% or more of the votes in the association need to propose the amendment to the owners. Then the board prepares the proposed amendment and sends a notice to the owners with the proposed amendment and sets a meeting to discuss the amendment for at least 30 days after the date of the notice. Then you have the meeting, and after the meeting, the board sends again the owners a notice with the proposed amendment, and this time a ballot to approve or reject the amendment. And the amendment is deemed approved if at least 30% of the votes in the association participate in the voting process. And of those 30%, at least 67% of the participators vote in favor of the proposed amendment. So this is for the communities that require 100% approval to get anything done. This is how you could get around that requirement. Once you meet those requirements, the association records the amendment and you are subject to UKIWA. That's anything to add, Valerie? That's it.
Yeah, I'm the one. A couple of things. I just did the math. 30% of the votes in the association have to participate in the voting process, and 67% of those voting have to approve the amendment. This means you could pass an amendment to adopt WUCIOA as your governing statute with as few as 20% of the voting power in your community. That's assuming only 30% participation and only 67% approval. That's the lowest threshold that you could pass this amendment with. And the other thing to keep in mind is that this is a simple amendment adopting WUCIOA as your governing statute. It's not a restatement or otherwise a document that's significantly revising your declaration. So then you would have to look at the question of dealing with bringing your documents in line with the statute that you're governed by. To the extent that there are provisions within your existing declaration that are inconsistent with WUCIOA, once you've adopted this amendment, those inconsistent provisions sort of, I mean, physically they're still there, but magically they go away because they're no longer enforceable. In other words, the statutory provisions in WUCIOA would trump anything inconsistent in your existing declaration once you adopt WUCIOA as your governing statute, unless there is a statutory provision that says otherwise. Most of the time the statute trumps. Every once in a while, proxies are a good example. There's something in the statute that says, unless provided otherwise in your governing documents, blah, blah, blah. And in that scenario, you would be looking at potentially certain provisions of your governing documents still being in effect. So just keep in mind that this isn't a full revision of your documents, unless that's also part of what you pay for when you work with your attorney on this amendment.
And there was a quick follow-up question, which is something I was going to add anyway. So the question is, what if you want to adopt most, but not all of UKIWA? So one way of kind of going around that until January 1st, 2028 would be to amend your documents, not adopting UKIWA, but your amendments would mirror the current language of UKIWA for certain sections. So you would not be able to benefit from that voting percentage we just talked about, but you could choose to voluntarily adopt some portions of UKIWA. That being said, January 1st, 2028, you cannot exempt yourself from certain provisions of UKIWA. So the ones you chose not to adopt would now then apply to you.
Yeah. And a lot of our clients have been either adopting WUCIOA or adopting restatements that are largely consistent with WUCIOA for a few years now. All of the restatements of the declarations and the bylaws that we currently draft are consistent with WUCIOA. I mean, unless we have a client that specifically asks for something that's different. And going forward, you know, I think our advice to clients that do ask for something different is probably going to be like, are you really sure you want to do that? Because in 3 years, you're not going to have a choice. So you know, why pay to restate now only to then have your documents be inconsistent with the statute in 3 years? So that's going to be something that we're, you know, talking with our clients in a lot of detail about. All right, I'm going to jump into the next question. I know we have a bunch in the chat, so we'll get to as many of those as we can. Our next question is, I read that the new WUCIOA law provides that written records must be provided within 10 days of termination of an association's managing agent or the board's demand. Our association has not yet adopted the new law. does this provision apply to us? The answer to that question is no. This provision does not apply to you unless you are subject to WUCIOA. That being said, I'd have to look at the record sections in the other parts of the statutes because I think all of them were amended in 2023, and some of them already contain requirements for the turnover of association records when there's a management change. So the specific 10-day requirement is only for existing WUCIOA communities, and that will go into effect on June 6th. But it's not a blanket absolute, you have 10 days or like you're going to get sued, right? 10 days for the bulk of the association documents. You can have up to 21 days under certain circumstances, and then you can take longer if you get a court order. The other thing that I would like to offer as an aside is if the association and its former management company and its current management company all get on the same page and agree to a schedule that's different than what the statute mandates, I find it very hard to believe that a court would find that inappropriate if it were later challenged, if everyone was in agreement. What the statute is intended to address is, I think, two things primarily. The first is that it's really hard for an association when it switches management companies for the new management company to get up to speed and be able to do business effectively on behalf of the association if it's missing half the association's records, right? And the second thing is, management changes happen all the time. And I would say probably 98% of the time, they happen with a minimal drama. Documents are turned over in a peaceful, proactive manner because everybody knows the business comes and the business goes. And I mean, it happens with law firms too, right? However, there are a few scenarios where documents are essentially held hostage by the prior management company, or there's just a lack of responsiveness when the new management company is trying to get documents from the old management company. We've even helped clients in a couple of scenarios where a prior management company was refusing to turn over association funds. So I think that is what the statute is intended to address, is situations that are not the norm, where there's this normally peaceful sort of routine transfer of records, but dealing with scenarios where that isn't the case. If you have not adopted WUCIOA, then what the statutes currently require is that you turn over the records, quote unquote, immediately upon termination. There's not a 10-day deadline or a 21-day, court order. Like all those details are just in the new upcoming changes to WUCIOA. There's no case law out there that says what immediately means. And I think then what we do is we always fall back on what is reasonable. And we just would always encourage all of our clients and all the management companies that we work with. And by and large, most of you guys do this, which is just to be as proactive as possible and as reasonable as possible. And once we start getting court cases to interpret these changes to WUCIOA, you can best bet that we will be talking about them here. So Katie, did you want to add anything to that?
Nope. So let's talk about droughts.
Okay.
I see that Washington State has already declared a drought for all areas except Seattle, Tacoma, and Everett. I believe that means that associations cannot impose any fines now for brown grass / not watering until the drought is lifted. In my experience, even if the grass is brown and not actively growing, weeds always find a way to grow. Can you give guidance to the associations on how to clearly communicate that while they cannot penalize anyone for not watering during a drought, they can expect owners to mow or cut and remove weeds from brown lawns? I feel it would be beneficial to notify all association board members about drought restrictions now. We have been talking about proactively sending letters of an educational nature to homeowners with brown lawns. The letters would encourage them to water one time, I think, per week or 1 inch. Their grass,
1 inch.
1 inch per week. Their grass may stay brown, but it won't actually die. Do you see any harm in sending letters like this? So we did look. The Department of Ecology for Washington State has declared a drought in the entire state for areas except Tacoma, Seattle, and Everett. They have a really nice map. You should look at it to see where specifically those locations are and see if your community applies. So RCW 6434-394 for the new act, RCW 6438-057 for the HOA Act and RCW 6490-512 for Ukiah all prohibit the association from imposing fines or assessments against an owner for reducing or eliminating watering of their lawn or vegetation during a declared drought. So that would say that if you are outside of the Seattle, Tacoma, Everett area, an association could not impose fines for or require owners to water their lawns. That doesn't mean that the association cannot still enforce or impose other requirements regarding lawn upkeep. It is just about water. So you can say no weeds. There's other stuff in those statutes about drought resistant landscaping. So if that's something you're thinking about, that's a different issue. But in terms of mowing the lawn, you can still require that they mow their brown or dead lawn and that they remove weeds. The association can encourage people to water once a week or 1 inch. I'm having an issue with the 1 inch because I don't know how you measure 1 inch of water across, but basically you could encourage limited watering, but we wouldn't send it to just the people with brown lawns. Send it to everyone. As long as there are no fines or assessments for the failure to water, you're not in violation of the statute, but we wouldn't recommend targeting just those who are choosing not to water. I think that is all I had to say about that. Valerie, do you have anything to add on that?
No, I think you covered that. And I think instead of getting to our last topic, which was not submitted by a participant, we're going to jump to some of the questions in the chat. The first one is there a statute that addresses whether a board member should abstain from voting on decisions concerning their own unit, or is this typically outlined in governing documents? If a board member disagrees with abstaining from voting on decisions relating to their unit, where would you direct them to find guidance on this matter? There is not a statute. However,
I wish there was.
Right, we do. We wish that there was. However, I think where we start and end on this topic is with the board member duty of care. Board members have a duty to act in the best interest of the association. They have to exercise reasonable and ordinary care, and they can't act out of self-interest. And if they're voting on an issue that directly affects their own interests, it creates at a minimum the appearance of a conflict of interest, but actually in most cases, I think it would rise to an actual conflict of interest, not just the appearance of a conflict of interest. And so whenever we are advising a client in a scenario like this, we will make a direct recommendation to the board that the affected board member recuse themselves or abstain from voting on that issue. And the scenario where we see this arise the most often, I mean, there's a few. One is the board is voting to take action on a delinquent account that might be the board a board member is delinquent. Sometimes it has to do with like an architectural request that a board member has submitted. So, I think that there's no statute, but this is something that turns on the board member's duty of care. If you have a board member that disagrees with this, I think what you also go back to is that this is a decision that the board gets to make as a whole. And so the board could take a vote to disallow the affected board member from voting on that particular issue. It does require that your board as a whole is willing to sort of stand up to the board member that's resisting that outcome. But that is one way you can handle the issue. Katie, did you have additional suggestions?
Yeah, so say the board member has sued the association, or is thinking about it, the board could also create a litigation committee that is comprised of at least 2, but maybe the rest of the board except this one member, because what you also want to do is make sure that you're keeping your privilege and you're not sharing privileged information with a actually adverse board member.
Yeah.
It is different if they're just interested because maybe their unit's getting repaired because there was a water loss. That is different than them suing the association for a particular matter. And so that might be more appropriate to have an actual committee who can make decisions without waiving the privilege, rather than just not having them vote on if their buddy should become the new association landscaper.
Yeah. Okay, our next question is related, I think, to the heat pump discussion. Bellevue has a nighttime noise level limit of 45 decibels, which is not realistic. How do we deal with that? I've been told it's a complaint-driven rule. Do you have any thoughts on that, Katie, or you want me to run with it?
I will let you run with it because I don't think I can gauge what 45 decibels sounds like.
Well, I think, that is where, that's part of where you go with this question. First of all, the heat pump bill is relevant to what restrictions an association can place on heat pumps within their community. And the default is that you have to allow them, and you're only allowed to place reasonable restrictions. I think there's sort of two different sides to the coin with respect to this particular comment. One thing is that a board could point to a local ordinance and say, we're going to use that as our reasonable limitation, and we're going to use the fact that it's part of the local code to support our assertion that this is reasonable. On the other hand, if most heat pumps that are constructed today would exceed that noise level, I think an owner would have a really good argument that that might not be a reasonable limitation because there's not a heat pump on the market that would qualify, maybe, right? Like, I'm not sure that there actually is or isn't. I'm not saying that, but that's the argument that an owner might be able to make. So I think the good news is an association you don't exist to enforce local ordinances about noise violations, right? And in particular, in this scenario, because there's a statute that says associations can't prohibit heat pumps unless there's a reasonable basis for doing so. I think if part of the concern is, well, if we let them install it, but it violates the code, then are we going to get in trouble for that? And I think your cover is you've got a statute that tells you have to let them install it unless there's a reasonable restriction that says otherwise. So I don't think the association is exposed to any significant amount of liability by allowing a heat pump, even if it violates that local ordinance. But this is also really specific. And so if you're dealing with this with any of your Bellevue communities, you should tell them to consult with their association attorney for advice on this. All right, next question. If an association's CC&Rs and bylaws lack specific qualifications for board members beyond being in good standing with their assessments, could the board implement additional criteria to evaluate nominees and potentially screen them out based on if they have litigation with the association, outstanding compliance issues, or other imposed criteria? The short answer to this question is no. The board on its own cannot change the qualifications for service on the board. This is the kind of thing that requires a vote of the ownership. Katie, would you like to elaborate? Or do you think that's all we have to say?
I think that's pretty much it. Basically, the owners alone are the ones it's in the statute and probably your governing documents, but more importantly in the statute that only the owners get to decide the qualifications of the board unless there are more qualifications in the governing documents. So that's it. The board alone cannot decide.
I am going to look at our next question and see. Okay, next question. I think we've got time to do this one. Can the condominium management company use the services of the condominium's law firm without first obtaining board approval?
It depends.
Yeah, well, and I think the short answer to this question is you have to look at the management contract, because often the management contract will give your manager the authority to incur costs of up to a certain dollar amount without specifically consulting with the board. And so number one, look at your management contract. And number two, if you're on a board that's concerned about this with your manager, have a conversation with your manager about it and agree to parameters and scenarios in which they are or not allowed to contact the association attorney without the board's specific permission in advance. Did you have anything to add to that one, Katie?
Nope.
No? Okay. We're at 10:59 and I don't talk fast enough to get to another question. So I think we're going to call it for today. Thank you all for joining us, and we will see you back here next week. Bye, everybody.